Now, with the permission of the President, it is my turn, or it is my opportunity to express my views on the theme premature release of prisoners, law, policies, and practices. I'll upload my presentation. It may take 1 minute. Please bear with me. Recently, we might have read in the newspapers, there are discussions going on 3 issues. In Punjab, demand to release Zarjuana and Bandi Sikhs. In Gujarat, question is being raised about release of Bilkis Bano. And few months back, questions were raised about release of Rajiv Gandhi's killers in Tamil Nadu. All these issues hover around premature release of prisoners. We all know the import of section 429 of CRPC is that every part of the sentence is to be suffered by the convict, and every word of the order is to be satisfied, meaning thereby there is no scope from incarceration or from the sentence. And there are public policies, laws, to ensure that the sentence is suffered in the manner it is prescribed in the policy. I would like to mention here that the role of the courts is to pronounce this sentence. How that sentence is to be executed is within the domain of the executive government. And Judge Sutherland, in the famous case United States versus Bench, has said that to render judgment is judicial function, and to carry out the judgment into effect is executive function, meaning thereby executives can frame policy how that sentence will be served and in what manner. It is in this background that premature release of prisoners becomes relevant. And IPC provides for it. It is not that it is at the whims and fancies of the government. IPC provides for premature release of prisoners. Section 54 and Section 55 are the relevant section. Justice Krishna Iyer again gave the philosophy behind premature release of prisoners. And he mentioned in All India Judges Association's case that law and justice are distant neighbors, sometimes even strange hostiles. And he advocated that premature release is a means to make law and justice as good neighbors. And it is in this background we can find out the justification of premature release of prisoners. Consideration in government policies about premature release of prisoners are basically 4 or 5. That is, in public interest, for human concern, for mitigating individual's misery, for rewarding his good conduct, and for ensuring his reformation, rehabilitation, and reintegration within the mainstream of the society. About the nature of premature release or clemency, in Ipuru Sudhakar, the Supreme Court has very clearly stated that it is not overturning the judgment of the conviction. The conviction will remain. It is only to mitigate the punishment. To mitigate the punishment in the interest of public, to mitigate the miseries of the individual, and to ensure that he is reformed and his good conduct inside the prison is rewarded. Let me now come to the sources of premature release in Indian statutes. Basically, there are 3 different types of authorities who have the power to cut short the sentence of a prisoner. The first one is the sovereign. Sovereign means the president and the governors of the state. And the sole reason for this is that clemency is the defining attribute of sovereign. मीनिंग देयर बाय जो कानून देता है वो कानून से माफी भी दे सकता है. दिस इज द फिलॉसफी. Secondly, the appropriate government, the elected government, and they exercise this power in public interest as well as to serving the cause of humanity. And thirdly, the prison authorities under the Prison Act and rule made under the Prisons Act. And it is basically to reward the good conduct of the prisoner inside the prisons and to motivate them to behave in a disciplined manner. Now let me discuss the laws, the policies, the tools, or the instruments of premature release in Indian statutes. Firstly, in the Indian Constitution, Article 72 for the President of India and Article 161 for the governors of the state prescribe then they can award pardon, or they can commute the sentence, or they can remit the sentence, or they can suspend the sentence of any convict on his request. And no question is being asked. No question would be asked why they have released, why they have granted pardon. The court can only intervene by way of judicial review in a limited manner if the power has been exercised mala fide or some procedural aspect has been neglected. The second instrument of premature release is the powers of the state governments or the central government, elected government, under the provisions of the CRPC. And there are two types of powers of the elected government under the CRPC. One is relating to commutation of the sentence, and secondly is the remission of the sentence. Commutation of sentence means changing the nature of the sentence, meaning thereby changing the category of the sentence, that is from death to life imprisonment or from life imprisonment to fine, etc. And that power is given under provisions of section 433 CRPC, restricted by 433A and 435. The second power is given to the executive government, the power to remit a sentence or the power to suspend a sentence. And that power is given. That power is given under section 432 of the CRPC. The state government, on case-to-case basis, on the request of the prisoners, and after obtaining the views of the trial court, can suspend or can remit the sentence of a individual prisoner. The fourth type of the instrument is provided to the jail authorities. The jail authorities can shorten the sentence of a prisoner, meaning thereby can shorten the term of the sentence by way of remission. In legal parlance, in legal documents, it is called shortening of sentence, but in jail manual, they have mentioned it remission by jail authorities. And how they do it? If a prisoner is behaving well, he is of good conduct inside prison, and he is performing the duties given to him inside jail, then the jail authority, by way of reward, can shorten his sentence. And the limit prescribed is up to 1/3 of the sentence. And with the permission of the government, 1/4 of the sentence, and with the permission of the government, it can extend even up to 1/3 of the sentence. And if the state government give any extra remission on the occasions of 26th of January or 15th of August or any other special occasions, then it will be in addition. Let me tell you, in 1 year in Haryana in 2014 and again in 2018, the Haryana prisoners got remission to the tune of about 250 days in a year. So that is the power of the prison authorities to shorten the sentence of the prisoners. And the next power to release a prisoner prematurely is that with the Supreme Court under Article 21 and Article 142 of the Constitution of India. In order to do complete justice they can exercise their extraordinary power under Article 42 and they can release a prisoner prematurely. And recently, in the case of Rajiv Gandhi's killers, the Supreme Court has exercised its extraordinary power under Article 142 and released them because they have already served 27 or 28 years of imprisonment inside the jail. There are certain issues which I will like to flag here because the time is limited. My only aim was to give you the instruments of premature release, the laws and the policies. Let me mention that for remission of sentence, no policy can be framed. Only procedural guidelines can be framed because it is on case-to-case basis. And in case-to-case basis, every case is unique. So no policy can govern it. But of course, guidelines can be issued to guide the procedures. In case of commutation of sentence, guideline can be prescribed to ensure that the exercise of power is not arbitrary. And Section 433 CRPC says that state government or the central government can exercise this power suo moto. Suo moto means without any application or request from the prisoners. And to give effect to this section of law, in the prison manual, a paragraph is added, section 516B of Punjab Jail Manual, here I am referring, just to give you an instance, where it is prescribed and it is mandatory for the jail superintendent to present the case of every prisoner for commutation who have spent 14 years in jail. So this is the legal obligations. It is not any favor, it is not any concession. It is the legal obligation of the government to consider. The government is well within their rights to reject, but they have to consider. So this is about commutation. And for that, to curtail arbitrariness, a uniform or a premature release policy is to be framed. Unfortunately, most of the states do not have a well thought out premature release policy. And it is necessary that the premature release policy should be there. And if it is uniformly discussed and provided, then it will be a very good solution. And in the premature release policy, these are the issues which are generally mentioned: classification of convicts, requirement of good conduct, remissions earned, old and infirm convicts, mentally sick prisoners, total and actual sentence served by the prisoner, frequency of PMR meeting, procedure, and constitution of premature release board. These are some of the important ingredients of those premature release policies. Time is limited, therefore I will only flag these issues which need consideration of the government, consideration of the prison officer, the correctional officers, because there are so many anomalies, so many misconceptions, so many wrongdoing so far as premature release of prisoners is concerned. And the reason is that this is the most neglected area. These sections are not taught to the law graduates. Advocates normally do not have practice on this aspect. In High Court, you will get only 1 or 2 lawyers who will be doing practice on it. And I have no hesitation in saying that even the courts, they are not having enough exposure to such type of law, and sometimes they are on wrong side. So I'll flag here only the issues and will conclude my presentation. The first issue is, should governor act as per the advice of cabinet when granting premature release? The judges are confused. In Maduram and in several other cases, they have mentioned that president has to act as per the advice of Council of Ministers, but they left the scope open for governors. President, no doubt, under Article 74 is bound by the advice of Council of Ministers, but governor do have discretion. And Madras High Court recently in Rajiv Gandhi's killers case brought out this aspect. So some clarity is required on this issue. Second, cap on shortening of sentence under prison rules. As I told you, in Haryana, and it must be happening in other states also, in 1 year, 250 days of remissions were granted to the prisoners under prisoners rules for shortening of sentence. Certainly there should be some cap. And in the Model Prison Manual, we have prescribed that cap. Third, ensuring time-bound disposal of mercy petitions. President K.R. Narayanan in 5 years did not decide even a single mercy petitions. So mercy petitions kept on pending. And in Shatrughan Chauhan, the Supreme Court has held that if the execution of your death penalty is not done within a stipulated time or within a reasonable time, then you get a right to get it commuted to life imprisonment. So we have to issue some guideline at least for time-bound disposal of mercy petitions. Rationale behind consideration of 14 years to present the case for premature release. 14 years was fixed when average age in India was 39 years. And 14 years used to be almost 2/3 active life of an adult. Now, average age is 69 years. We need to revise this limit if we really want that justice is done. Today, if Razwana is released from jail, he is 56 years. He still have 15-20 years of active life. Can we have it? So a thought is required to be done on this limit of 14 years for consideration for premature release. Number of mercy petitions and number of type of reliefs. How many times a prisoner can file mercy petitions? This is to be formalized. Standardization of premature release policy. Throughout the state, throughout the country, we should have one uniform standardized premature release policy. Uniform scale of remissions by the prison authorities. The scales are again varying from state to state. Which premature release policy should be relevant? The Supreme Court in Madhuram's case and in Jagdish said that the policy prevailing at the time of conviction should be the policy under which the case of premature release of a prisoner should be considered. But I think the Supreme Court in these cases have erred, because it should not be the time of conviction, it should be the time of commission of crime. Because here Article 21 or Article 20 come into play. Then uniform formula to calculate custody period. There should be a uniform formula to decide how much custody a criminal has undergone, so that the court can take appropriate view on it. And it will be good if at all India level a uniform formula is prescribed. Important question is to be asked by the public whether the Supreme Court is justified in exercising its extraordinary jurisdiction under Article 142 in releasing a convict, prematurely releasing a convict, because the Supreme Court has already decided the appeal and have upheld the conviction, have upheld the penalty. Can they again revoke their own powers to undo that? It is an important constitutional as well as legal question which need to be deliberated upon. These were some of the issues which I wanted to flag. I'm going to finish my presentation with these conclusions that premature release is not an absolute right. It is a prerogative of the state, subject to good conduct of the convict. And it is relevant also. It is needed to ensure reintegration of the prisoners and reformation and rehabilitation of the prisoners who are serving their sentence. I conclude by saying that Abraham Lincoln, and I subscribe to this philosophy, Abraham Lincoln once said, "I have always found that mercy bears richer fruit than strict justice." This is how we need to rationalize our premature release policy. I stop here. Thank you very much. If there will be any question, I will be dealing with it at the end of my presentation.